and also to all of you for being here this afternoon. This talk will try to make one big, broad argument, which is quite self-evident, so should not be controversial, but is kind of controversial because there are a lot of people out there who tend to disagree with it. And the argument I want to make is that international criminal law and international criminal justice are inherently political. Now, for political science scholars, that's pretty normal to say, but for legal scholars and people who work in international criminal courts in general, this tends to be quite a polemical assessment to make. One of the questions that I ask in the book is, why is it that the International Criminal Court, the ICC, why does it seem to be able to deliver justice only on behalf of states rather than on behalf of communities or on behalf of victims who are affected by atrocity crimes? What are the implications of such a state-oriented judicial mechanism? And how does this state-oriented judicial mechanism square with the ending impunity narrative that the International Criminal Court uses, but also the justice for victims narrative, which tends to be the two leitmotifs of the international criminal justice regime, ending impunity and delivering justice for victims. Now, to briefly present the International Criminal Court, what it is and what it does and how does it operate, the ICC was created in 1998 at the Rome Conference. And its founding document is therefore called the Rome Statute. The court became operational in 2002 after a number of, the minimum required number of states had ratified the Rome Statute. So in 2002, the court became operational. It's been about 20 years now. The court was founded by a treaty. So it is a treaty-based court, not a UN court. What does it mean? It means that states willingly sign and ratify the Rome Statute and become members of the court. Unlike other ad hoc courts such as the Court for Rwanda, the Tribunal for the former Yugoslavia, those were UN courts, so there were no membership per se. But for the ICC being a treaty-based court, that means that there are states that are outside of the purview of the court, the United States, for instance, other states such as Russia, China, basically all Arab countries. The large membership of the court is made of primarily of African states, Latin American states, Western Europe, and East Asia, Japan, for instance. The court has jurisdiction over what is called the most serious crimes of concern to the international community as a whole. That's what's written in the preamble. And those crimes of concern are genocide, war crimes, crimes against humanity, and the crime of aggression. Now, you would recall that these are basically the same crimes that were being tried at Nuremberg. So there is some continuity from Nuremberg to The Hague in regards to what is deemed to be the most serious kind of crimes, atrocity crimes. Now, for states that are outside of the purview of the court, states that are not members of the court, meaning that they are subjected to the jurisdiction of the court only if they have been referred to the court by the UN Security Council. That's what happened twice now with Libya and Sudan. Those two states are not members of the court, but the situations there have been referred to the court by the UN Security Council, which has the power to refer cases or defer cases to the court. Now, the ICC being an international court that is made of states, only states can join the court. Yet the court being a criminal court also means that only individuals are prosecuted. So legally speaking, the court cannot investigate a state. Although we hear a lot over the past couple of weeks, for instance, with the situation in Palestine and Israel, that this court is about to start investigating Israel for war crimes. That's not the case. The court cannot investigate states because it is a criminal court. It upholds only individual criminal responsibility, meaning only individuals can be put on the court's docket. Now, this court and all other international courts, the ad hoc ones and the permanent one, I argue, operate in a world that is made primarily of states. What does it mean? It means that states are able to leverage the courts and the legal systems in order to pursue their own political and security interest. And then the ICC is unable, cannot resist being instrumentalized by states. Now, this is self-evident if we are thinking about great powers who are able to use the international system in pursuit of their own benefits. For instance, the ways that the Security Council is able to refer or defer cases to the ICC without itself being subjected to the ICC's jurisdiction. Remember that the Security Council gave jurisdiction to the court in the situations of Sudan and Libya, yet 3 of the 5 permanent members are themselves outside of the court's jurisdiction. The US, Russia, and China are not members of the court. But the more interesting point I'm trying to make here is not just that states can use the court for political and security interests, but rather that even states that do not wield great power in the system. These are what I call the weaker systems, the weaker states in the international system. And I would certainly count African states as fitting that label. These are states that do not wield the great power. But even those states are able to leverage their stateness in order to use the court for their own security and political interest. Now, I do not want to give the impression that the court itself is just vulnerable to this manipulation, because the court also is an agent in itself. So the court itself is a political agent, and it is not always in competition against the state. The court and the states can find convergence into some areas where they can work together and they can both benefit from that collaboration. This is what I call the accommodation and collaboration that is often visible in the working relationships between states and the ICC. The main arguments I develop in the book, to summarize it briefly, is trying to understand why and how do states engage with the ICC. In other words, what kind of mechanisms and strategies do they develop in reaction to resist the international system, or to work with the international system by perverting the norms to make them fit their own interest. And to what extent are weaker states in the international system able to use the ICC as a leverage in the pursuit of their own domestic political and security interests? Consequently, what can this tell us? What conclusion could we draw from this in regards to the primacy of state interests, even when it comes to international justice? The empirical work focuses on four major themes that are all at the intersection between states' power and states' interests regarding the court, the ICC, and international legal norms. The first one that I'll focus on is the strategic use of self-referrals. There are three ways that the court's jurisdiction can be triggered. How do the prosecutor take up cases? How does the prosecutor start investigations? Well, the jurisdiction must be triggered by one of three ways, meaning that when a state is already a member of the court, the state can write a letter to the prosecutor and say, hey, we have a conflict here. Would you come and look into it? That's what Uganda did regarding the LRA. That's what the DRC did in the conflict in Eastern Congo. That's what Ivory Coast did. That's what Mali did. That's what the Central African Republic did. So these states write a letter to invite the prosecutor to come and investigate because they believe that there may have been crimes committed there that would fit the jurisdiction of the court. Now, this is an interesting way of using the state referral mechanism because this was not written into the Rome Statute. When states were creating the court, when they included state referral in the Rome Statute, the thought was that when state A is doing something that is in violation of international law, or when there is a conflict in state A where these kind of crimes are being committed, then all the states would come in and refer state A to the court and ask the court to get involved. But that's not what happened. It did happen later on once in the case of Venezuela, where you had a number of Latin American states and Canada did refer Venezuela to the ICC, but that happened much later. And that happened only once. In all other instances where the state referral mechanism was triggered, it is a state that goes to the court and say, I want you to come and investigate me. Now, this is also a kind of a misnomer to portray this way, because what these states do is tell the prosecutor to come and investigate rebels in their territory or political opposition in their territory. Now, what leads these states to do this? I contend that states have been using the state referral mechanism in a very different way than it was envisioned, because they realized that this could be a tool they could use to incapacitate their local adversaries, whether that's the rebel leaders or political opposition. That's why the people you would find in prison in The Hague right now or on trial at the ICC are rebel leaders. You do not have state government forces. You don't have militaries from the government forces in this. All you do have is rebel leaders, military commanders that were fighting the regular forces of the state, and a couple of jihadists. So literally all these people who are being prosecuted by the court are enemies of the state, or people who were in power and have lost it, have become political adversaries of the current governments of those states. So Gbagbo, former president of Ivory Coast, is one example. In the future, if former President Bashir of Sudan ends up at The Hague, that would also be another example. So either enemies of the state, rebel leaders, political opposition, or people who had been in power but have lost it now, have been on the other side of the fence vis-a-vis the current government of these states. So these states would refer themselves to the ICC. They tend to have something in common. They tend to be fragile or fragmented. The political regimes in the states that self-refer tends to be governments that came to power through a military coup, or the states that tend to refer themselves to the court because they're dealing with some post-electoral violence in the aftermath of elections that were contested. In any case, you do have either a very volatile political situation, or you do have a state that is so weak that is trying to assert legitimacy and control its territory, therefore appealing to the court in order to incapacitate rebel leaders or local adversaries in their territory. So that's one of the major themes. The second one that I'll look at is the complementarity between the national and the international justice systems. When the ICC was created, it was created to be a court of last resort. Because again, the idea of creating this court goes all the way back to the Nuremberg trials, and even in the Genocide Convention of 1948, the UN General Assembly had invoked the idea of creating a permanent court that would deal with genocide. And the General Assembly appointed the International Law Commission, the ILC, to try to do two things: to draft the code of crimes that would be under the jurisdiction of that court, but also to try to create the court itself. But this was in the 50s, 60s, 70s, so it was the Cold War, so the Cold War got in the way. The International Court was never created until in the 1990s, where at the end of the Cold War, there was renewed interest in creating this court, especially after Rwanda and after the war in the Balkans. It became one of the top priorities of the international community to create such a court. But the idea had always been that this court would be a court of last resort, meaning that the court will intervene only if the state where these crimes are being committed is unable or unwilling to investigate and prosecute. But that's not what's been happening. In a lot of these situations where the ICC got involved, what we see is that the state would still have its jurisdiction. The state would still have its courts and lawyers and judges and totally able to actually investigate and prosecute these cases, but yet decided to refer themselves to the ICC and let the ICC handle with this. So the ICC becomes basically a bad bank where the states would hand over some of these thorny issues in their territory instead of trying to deal with them themselves. The third theme is looking at the question of compliance and non-compliance with the court's rulings. If you are a member of the ICC, then you are legally bound to comply with the court's rulings. But what I argue here is that compliance and non-compliance are dynamic tools that states engage in when working with the court, when dealing with the court, and the level of compliance very much depends on the level of risk for the political elites. So when the fortunes of the political elites or of the government changes, then we see the level of compliance that changes. And Kenya is one of the interesting cases here because some individuals who were involved in political violence after the elections in 2010 were investigated by the court and they were being prosecuted, what they ended up doing is joining their forces, running into the same political ticket while they were adversaries during the conflict. And then they ended up winning. And these two individuals are primarily the current president of Kenya and his deputy president. So they became allies, became part of the same political coalition run on the anti-ICC agenda. They won the election, became president and vice president, and used the state to blackmail the court. A lot of witnesses disappeared. Some were killed, others were intimidated to a point that they recanted their testimonies. They refused to hand over documents that the prosecution needed. What ended up happening is both the cases against the president and the deputy president were dropped because the prosecutor could no longer hold into the evidence that they initially had in order to be able to pursue the cases. And finally, the other major theme I'll look at is the use of the ICC in domestic political disputes. So this is no longer just in times of conflict, but also handing over political adversaries to the ICC, which is exemplified by the Ivory Coast case, where President Ouattara handed over his main political rivals, President Gbagbo, former President Gbagbo, and Charles Blé Goudé, who was Gbagbo's Minister of Youth, and while at the same time refusing to hand over to the ICC Simon Gbagbo, who also is wanted by the court. So I contend ultimately that African states too have been able to instrumentally and strategically use the international criminal justice to their advantage. Now, this matters because the scholarship regarding Africa's relation to the court tend to just focus on the fact that everyone that's been prosecuted at the court has been African. Now it also is changing a little bit because now the court has taken interest in other situations outside of Africa. So the court is involved now in Israel, Palestine, in Georgia, not the state where I'm at, but the other Georgia, in Ukraine, in Venezuela, etc. But prior to what's happened in the past few years, all the situations in which the court had been involved had been located in the African continent. So obviously there were a lot of discussions about the court operating within a very racist, or at least a very biased framework, and which I do not, which I do not reject totally. I've written on this too, because I definitely believe that international criminal law and international criminal justice built upon imperial and racist logics, and they are perpetuating this dynamic too. But what I wanted to argue also is that there is more going on here. It is not just that the courts targets Africans. I think it is interesting to look at how African states themselves are engaging with the court and why they are engaging with the court. I propose also a theoretical framework that tries to put into categories how states that are engaging with the court behave, depending on the trigger mechanism, how the court got involved in those situations, depending also on who are the primary targets of the investigations. So when it is a state referral, when it is a state that willingly goes to the ICC and tells the prosecutor, we want you to come and look into what's happening in our territory, the outcome is typically selective investigation and prosecution. So the prosecutor will investigate primarily the enemies of the state, the rebel leaders or the local opposition, and leave alone the state forces. For instance, Uganda is one of the primary examples of that, where we have had the ICC focusing primarily on the LRA, while it's been widely documented that the government forces of Uganda also have committed a lot of atrocity crimes. In the case of the UN Security Council referrals, then what the outcome tends to be of these cases is a stalemate, because these states have not willingly invited the court. If the court is targeting state agents, then it tends to be a stalemate because the state will withdraw cooperation. If the court is targeting non-state agents, then there is a possibility of a breakthrough there, which we are seeing right now. I think last week the ICC prosecutors team was in Sudan, trying to talk with the current Sudanese authorities regarding the case of al-Bashir, and trying to either have him sent to the Hague to stand trial, or the ICC itself holding the trial on site in Sudan, which is very unlikely too, because there were at some point in the past where they had thought about holding some of the hearings, at least in Uganda, against the LRA, but the judges had invoked security issues and logistical problems, and they decided not to do it. And I guess also that it's much more comfortable to be in The Hague than to be in Gulu for the judges. And finally, when there is a proprio motu trigger mechanism, this is when a state is already a member of the court, potential crimes are committed in that state, then the ICC prosecutor can, in her own volition, try to initiate investigations. But after the preliminary examination, she would have to go back to the pretrial chamber and ask and present the preliminary evidence and ask the judges for an authorization to open a full investigation. In these instances too, the outcome is a selective investigation and prosecution, depending on whether the investigation targets primarily the enemies of the state or the sitting government officials. The second theoretical framework that I propose is what preemptive actions do states take when there is a hint that the ICC may be involved in a situation. In the case of UN Security Council referrals, what we see is the P5 members using their vetoes to stop resolutions to be passed. This has happened in the case of Syria, for instance, Syria, which is not a member of the court, but there's been instances where some states in the Security Council have proposed to give the ICC jurisdiction for it to get involved, but then there's been some vetoes being used by China and Russia. So we see here that states would use their P5 member status to shield their friends and allies and stop resolutions to be issued that would allow the court to get involved. But other instances also for the proprio motu, we see that states would preemptively withdraw from the court if they were already members. That happened in the case of Burundi. That was a member of the court and at some point decided to leave. In the past, there's been a threats of leaving the court that came from South Africa and the Gambia. But the Philippines also have left the court when it was clear to them that the court would be investigating some crimes against humanity being committed there in the wake of the war on drugs that the Filipino government has engaged in. But we've seen also threats that has been issued against the ICC personnel in order to stop them from even thinking about getting involved in some situations. So there's been the cases of the United States, for instance, threatening the court. That's been ongoing for a long time, but more recently, there's been the sanctions that were issued by the Trump administration against the 4 top-level officials in the ICC's prosecutor's office. We've also seen states such as Canada, for instance, which is one of the big funders of the ICC, and Germany too, speaking out strongly against the ICC getting involved in the Israel-Palestine case, or China also speaking out strongly against the ICC getting involved in Myanmar in the Rohingyas situation. So I'll repeat the main argument again, which is that even states that do not wield a global power are able to use international courts in pursuit of their interests. And those states are able to leverage their stateness to obstruct, influence, or instrumentalize the court. They strategically self-refer situations to the ICC. They shift between compliance and non-compliance depending on the political risk of the political elites, and they outsource their political disputes to the ICC. Now, why would that be a problem? Well, it is a problem because the ICC and the international criminal justice system are still in denial about the political dimension of the international criminal justice project and its instrumentalization for political and security goals. For a long time, the international criminal justice project has sought to divorce itself from politics for the anxiety of being viewed as being a mere political device in the hand of powerful states. Because the project itself, the International Criminal Justice Project itself, holds the belief that personal accountability for atrocity crimes is a widely adopted norm in the world now. This is where the justice cascade argument comes into, that there's been progress that's been made, that now it's being widely accepted that atrocity crimes must not go unpunished, that people will be held individually accountable for committing genocide, war crimes, or crimes against humanity. That this is now a given idea, that sooner or later, whoever has committed this will be brought to justice, or at least there's a widely accepted norm that these crimes must not go unpunished. But I argue that this justice cascade argument may not be as strong as we thought, or as we tend to believe. I mean, this is a noble and lofty goal and everything. But I think if we are only paying attention to the number of trials and committees of inquiry and justice and reconciliation committees, if we are paying attention to this, which what my friend Kelly Jo Bruin called the cascade scientism, we are missing out the political dimension of this, of the instrumental use of these TRC mechanisms and transitional justice and commissions of inquiry and trials. The other point I want to make also is that it is not that the ICC has become a political institution or has become politicized. It is that it always has been a political project. The international criminal justice has always been a political project, even if we go back to the Nuremberg trials. The founding document of the ICC, the Rome Statute, is a political document. It was negotiated by states which had a lot of competing interests. For instance, the involvement of the Security Council in the court. It was a very heated debate at the Rome Conference. To what extent could the Security Council be involved in the court? States from the Global South wanted the court to be totally dissociated with the UN Security Council. They wanted the Security Council to have no power whatsoever in regards to the court, because they had feared an instrumental use of the court by the states that sit at the Security Council. Another example is during the drafting of the codes, even before the Rome Statute, when the International Law Commission was drafting the code of crimes against the peace and security of mankind, states from the Global South had a much longer list of potential crimes to be included there, which that list, for instance, included colonialism. They wanted colonialism to be part of atrocity crimes. They wanted the use of mercenaries to be part of atrocity crimes. They wanted environmental degradation to be part of this list. They had, I think, in total 12 such crimes. But of course, they faced this opposition from Western states primarily, who did not want a criminalization of colonialism, because they argued, well, this is a thing of the past anyway. Why would we bother making colonialism a crime against humanity? In the end, what I'm pointing out here is the political dimension of this project in itself, because the material, temporal, and territorial jurisdiction of these documents and of these courts are the result of power dynamics at the international level. What counts as core crimes, what counts as crimes of concern to the humanity, who counts as part of that humanity, the non-retroactivity. The ICC, for instance, can only focus on cases that occurred after 2002. The prosecutorial discretion, all these things are enmeshed in political and racial constructs. But for today's talk, I'm focusing mostly on the political constructs, not the racial ones. I will talk, I think, for like 3 more minutes, and then I will conclude briefly. So what we ended up having is a system that is in denial of its political dimension and of how it is often politically instrumentalized. The ICC refuses to see these political aspects, and despite its shortcomings, tries to focus on 2 main narratives: the ending impunity narratives, that none of these crimes shall be unpunished, and the justice for victims narratives. So the victim becomes the narrative through which the court compensates its shortcomings, its limitations. The court reorients itself into working for the victims. The justice for victims becomes the ultimate telos, the raison d'etre of the International Criminal Justice Project. This is how the project legitimizes itself. And in the words of David Luban, quote, "International criminal justice will always be an extraordinary institution that perpetually needs to persuade the world of its own legitimacy." To conclude, the ICC was created in 1998, and it was welcomed in a very triumphant language, because it was believed that we were entering, finally, this is again the end of the Cold War, we were entering an era of accountability. And then Secretary General of the UN, Kofi Annan, said when the court was created that the ICC is, quote, a gift of hope to future generations and a giant step forward in the march towards universal human rights and the rule of law, end quote. 2 decades later, we see that victims have felt abandoned and frustrated by the court. The court has convicted only so far 4 individuals after 20 years of operation. State compliance and state cooperation remains elusive. The ICC is nearly incapable of successfully prosecuting high-ranking state officials. The fundamental role of criminal trials in the Hague justice system are in question, although the Hague justice system, of course, refuses to grapple with these questions. And then what's the future of the court? And what's the future of this international criminal justice project? It's unclear, especially that the court is entering some pretty rough waters lately, to the point that it had issued a review report by some experts that were hired to look into how the court is operating and to find potential solutions, issue recommendations. They issued the report about 2 months ago. It's 348 pages. There are a lot of recommendations about how to move forward and to save the court from collapsing. But this report has mostly focused on the governance of the court. It does talk a lot about budget issues and judges who are abusing, mistreating the people who work for them, and lack of compensation for the victims, and the court still being very remote to the people that it is supposed to be serving. But I think that the broader questions about the crisis of the international justice system have not been addressed in this report. Also, that as long as the ICC views itself as central to humanity's progress, it will be difficult for the ICC to notice the extent to which the international justice system is flawed. Why? Because it is still viewed as if criminal justice and individual accountability are the appropriate, if not the only appropriate venue to deal with atrocity crimes. The prosecutor Bensouda herself said last year that, quote, without the ICC, we will regress into an even more turbulent world where chaos, volatility, and violence take the upper hand as inevitable norms. So they are still claiming that the court is changing the world simply by existing. Therefore, despite all the troubles that the court encounters, that the ICC is failing its way into success. And I'll stop talking now. Thank you for your attention.
Thanks very much, Oumar, for that really rich and great talk. We're now open for Q&A, so if anyone wants to speak up and ask a question, then you can use the hand raise feature, or type a question in the chat and let me know, or turn your video on and wave. Does anyone want to go first? Allison?
Hi, thanks very much for that great overview, and I think a very useful, incisive critique. It's interesting because I think that the Justice Cascade has something to offer that is different than its own claims. I guess what I would like to ask is whether you would consider that, of course, the ICC is political because all global governance and global institutions are political. And all global governance and all global institutions make apolitical normative legitimacy claims. So I'm not surprised. But if we consider about kind of many aspects of the international human rights regime, which is how I look at it. I don't look at any single institution. I look at the regime as an interconnected whole, that they may be doing work beyond their own intentions and beyond their own awareness. It will always be partial and limited by the dynamics of state sovereignty, not just limited, but as you say, co-opted, perverted, etc. Nevertheless, I'm making a little sort of Pinochet effect argument here, right? And so what's cascading is not justice, but what's cascading may be some dimensions of accountability, which is the opposite of impunity. And the two elements I would point to that I would wonder if you can address are, first of all, the expansion of norms. So you observe, I think, very closely and skillfully the dynamics, the referral mechanisms, the compliance, but simply the introduction of cascading norms like rape is a war crime, how do we deal with accountability for child soldiers, these things that ripple, I think, maybe ripple is better than cascade. And the second sort of long-term partial effect would be linkages in the kind of repertoire of the regime. So for example, linkages to regional courts, jurisprudence, and delegation, and cascades back and forth, and with the Pinochet case, even to onward linkages to national courts. So sorry, that was a kind of a long windup, but I'm proposing an alternative critical perspective, and that the work may be in norm expansion and regime linkage, building an international regime beyond the ICC itself.
Thank you. That's a very insightful comment. I got, I think, 3 main points in your comment, and I hope to be able to address each of them. I'll start with agreeing totally, 100% with you regarding the fact that the regime will always be partial, limited, selective. So international justice, international human rights is always politically selective, and prosecutors make deals with people all the time when they're pursuing a case because they may need witnesses, and they do offer incentives to people to cooperate with them so they can convict someone else. So justice, this is how it operates domestically, internationally. And there are logistical questions. For instance, if the ICC prosecutor goes in a state and wants to investigate government military forces, well, their investigators could be expelled from the country. They could be denied entry visas. So there are logistical questions that they have to take into consideration. And that's totally fine. And I think it's not a bad thing. I mean, it could be way better if justice could be equitable, but that doesn't happen. That probably can never happen. So it's not a bad thing that justice is selective. The ICC, though, refuses to accept that fact, and they refuse to come out and say, look, we have an incredibly difficult task to do. We are doing what we can, and we may fail the victims. Oftentimes, they may have to wait sometimes 15 years for a trial to end, and then the guy get acquitted. But we are doing the best we can. But this is not the discourse that the ICC is giving, especially to the victims who hinge all their hopes into a court that promises to deliver justice to them, but ends up basically coming short. So this, I believe, goes back to the anxiety of the ICC itself, that the ICC is so anxious about being a failed project that it refuses to even acknowledge its limitations and curtail its ambitions. They were handed over an impossible task, which they obviously cannot meet, but they will not acknowledge that. The second point is regarding the expansion of norms and the justice cascade. I'm not totally rejecting the justice cascade. I think it's a valuable frame through which we can understand the evolution of the regime. And even just the case of the ICC, I didn't talk about this in my talk, so I could give the impression that the ICC isn't doing anything good, but that's not the case. I mean, there's been norms that have been put in place by the ICC that may cascade in the future. For instance, the child soldiers. The ICC has advanced international jurisprudence regarding the use of child soldiers. Cultural heritage. For the first time in the history, someone was prosecuted and convicted solely for the war crimes of destroying cultural heritage. That have never happened in the history until the ICC convicted Al-Mahdi. Just last week, in the conviction of Ongwen, the former LRA, former child soldiers who turned out to be later one of the commanders, one of the crimes that he's been convicted for, I think he was convicted for 61 counts of crimes. A couple of them has to do with the forced marriages and impregnating his wives. So sexual violence, the ICC has been at the forefront of introducing all these things into jurisprudence. So definitely, I agree that there is some justice cascade going on there. But I go back to the idea that it is not just that all these things have been widely accepted and adopted by the international community, by the state. I point out to the instrumental use of the system itself. Regarding the regional courts and the delegation, one project I'm working on right now is the African Court of Justice, which has been revived in the tensions between Africa and, I mean, I don't want to say Africa, but the African Union and the ICC, and they amended the Court of Human Rights that they had to give it criminal jurisdiction as well. So they adopted the Malabo Protocol to create an African version of ICC. And one interesting thing about it is the court that they're creating has a much longer list of crimes they could prosecute than the ICC has. Remember, the ICC has 4 crimes. The African states went back to what they were proposing in the 70s. The longer list of crimes, this is what they will put into place in the court that they will be creating. So that also could be viewed as a result of the limitations of the ICC when African states have tried to see if we are creating a code, we do not want to replicate what the ICC. We want to create a code that would deal with these crimes that are of concern to us as Africans. So the crimes include, for instance, the military coups, degradation of the environment, the dumping of nuclear waste in the continent, etc. I'll stop there.
If I could just add, I don't want to, predominate on it. I know others want to step in, but just on that last point, one of the reasons I asked that, I've done a little bit of the global governance side. I haven't worked specifically on the ICC, but I'm very familiar with the Inter-American system. And, one of the reasons that Latin America has somewhat forged ahead and gotten a little bit better compliance and a lot of norm expansion, precisely environmental issues, disability, domestic violence, all kinds of issues, is because you've got that meso layer. And Africa has been disadvantaged about 6 different ways. So that African Court of Justice, I think, is critical in terms of getting an architecture and a repertoire that can possibly advance this project beyond the limitations of its original design. Thanks.
Anyone else have questions to add in? Raymond?
I thought I saw James and some other people that were maybe ahead of me. Otherwise,
Vladimir too.
Otherwise, I have a very fascinating analysis. I have 2 short questions for you. And, I always kind of then wonder after a talk, all right, so now what? And so the now what I want to put to you. So are there alternatives externally? I think you touched a little bit on the African courts that emerge, alternatives to the idea of the ICC. So that would be the external kind of additional reform or something like that. But then there's probably also internal reform opportunities for the IC that would advance the cause. Or extreme, the extreme case would be that this is a failed institution and, it just has to kind of wither away and be replaced by something else. And if so, what would that be? Thank you.
Thank you, Raymond. These are very, very good questions. So what's the alternatives? What's next? So now what? Where are we going with this? I think there are potentially a lot of possible scenarios here. One being that the court could at some point become obsolete, maybe not disappear, because IOs don't die that quickly. Even when they become irrelevant, they somehow stick around because they give jobs to some people, I guess. But there could totally be a feature in which the ICC will no longer be central to criminal accountability for atrocity crimes, especially if there are strong regional mechanism to deal with this, but also if states take the necessary steps to deal with these crimes, because again, the ICC is supposed to be a last resort, a court of last resort. The former prosecutor of the ICC used to say that the ICC will be successful the day when they have no longer any case to prosecute, because that would mean that all states are prosecuting the cases and therefore the ICC would have no work to do. But that's probably the hopeful view here. The other one would be that the ICC will keep running into crisis after crisis, especially that now they are entering into uncharted waters. They're dealing with the Israel-Palestine case, and they are dealing with the Afghanistan, the United States case. there is still the Iraq UK case there. So the backlash against the court will be strong. That would potentially put a lot of unknowns in the near future for the ICC. The third point I want to make here is that maybe the future of global justice is local. Maybe the ICC would do well to curtail its ambition, know its limitation, and work with the localities where some of these crimes are being committed, help us strengthen those judicial mechanisms, and be willing to let all the versions of justice play out. So justice does not need to always be trial justice. And I think there is a lot of possibilities out there of dealing with these crimes, especially because a lot of these crimes tend to occur in conflict situations. And the ICC prosecutes individuals when in fact there is a larger number of people who have been involved in these situations. So what is the deterrent effect there? What does it make to go and pick up a couple of LRA commanders, take them to The Hague, subject them to a trial that does last 10, 15 years, sentence them to, I think on average so far, the sentences at the ICC has been around 12 or 13 years of prison. So could that energy, resources, time better be spent in addressing the conflict at its roots and allowing all the versions of justice to play out rather than pursuing the trial of one individual at the cost of, I don't know what the budget of the ICC is, but it's quite substantive.
I think Jan was next and then Ricardo.
Thanks, Kai. Oumar, how about this? That the arena in which ICC functions is the middle powers, and smaller countries have profound interest in international law, because that is their main card to influence, versus superpowers in relation to whom international law is another obstacle, as well as their satellites. So this is the arena, middle powers, small powers versus superpowers. In that arena, ICC navigates, coasts, improvises. It's kind of an international jam session with, of course, a nice aura of legal language. But if we then look worldwide, how many middle powers are there? And what are the chances, say if we look 50 years ahead, what are the chances? The superpowers are not having such a great time in many ways. You know, some are always rising, declining. It's like a permanent crisis. But sorry to speak so long.
Yes, I agree. These are very interesting dynamics playing out at the ICC, especially because if you look at the big funders of the ICC, those who give money and keep the machine running, they are typically the middle powers. Canada being one of the main proponents of this international justice project and one of the main funders of the ICC. Japan is also another one of the big funders. And then there are a lot of European countries, even very small European countries like Liechtenstein. I don't know how to pronounce the name, but very small, tiny in Central Europe. But these are the countries. And there's also, of course, the Netherlands, where the seat of the court is located. Yes, there is a lot of vested interest, and I don't mean interest here in the pejorative way, but there is a lot of attention that these powers have given to the court and to the international justice system. It also plays out to the identity that these countries are projecting on the international scene, which goes back to the constructivist point that we were discussing earlier.
Ricardo?
Yeah, thank you. I have a bit of the sun. There are two things, and I want to continue on Jan's. This notion of localization and what you would say locating it in the African continent or wherever. Don't you think that would be, because if we think of the ICC as an extension of colonialism and new colonialist type of extension of that, would localization necessarily resolve the problems, or would it just be easier for these power relations for sort of self-management, and whereas a lot of these problems are also externally driven? So is it a way to bypass and confront the central question is, how do you subject globally all countries, whether it's the US, the UK, to the same set of rules? And because I'm a bit worried if you say localization, then it's a way of sidestepping the power relations, but not confronting the key thing. Now, if you go to the Congo and you ask yourself, yeah, who is responsible there? So you can now say, yeah, there's this African warlord and this, but what about the Canadian companies? And so how are you going to do all of this at a local level without addressing the power relation, which is a complex question. I'm just getting your views. Me personally, I see the ICC as just an extension of colonial rule or some form of new colonial rule. That's all it is. And human rights, in any case, has been an extension of imperialist rule, if I can just provoke you in that sense. Yeah, so that is my question. Thank you for a wonderful presentation, by the way.
Thank you. I do agree with you. I wouldn't probably have put that so bluntly, but I do agree with you that the foundations of this whole system, international criminal justice, international law itself, the foundation goes back to the colonial encounter, and there's still a legacy, a strong legacy there. I also agree that localization would not necessarily solve all the problems, because even if the African states will create this court and it became operational, so far there's been a very few signatures of the Malabo Protocol. But even if the court would become operational, there will be also power dynamics playing out among African states there. So you may have those same problems if the court would, I don't know, maybe take up cases in investigating the conflict in the DRC. How would the DRC react? How would DRC's friends react? And depending on who is being prosecuted. There's also the question of the official immunity for official capacity. And that's been very controversial in the Malabo Protocol, because what the African states did was include in the protocol that officials acting in their official capacity will be immune from prosecution at the court. So basically, they are already giving themselves a free pass and putting themselves out of the reach of the future to come African criminal court. So yes, these problems would not necessarily disappear with localization, but there's one, I think, positive that could come out with this localization is the sense of ownership, that African states would definitely own the court that they have created in their continent, despite its limitations, because a lot of the things that they had proposed in the 90s while creating the ICC, had been dismissed. And they had actually predicted a lot of these problems with the politicization of the court. It's a funding that could be potentially used to exert a pressure on the court. If you go back to the deliberations of the minutes of these meetings in the 90s, you would see, I don't know, representatives from Algeria, for instance, making this exact claim that the Secretary Consul should not have the power to refer cases to the ICC, that states should not use their resources just because they're funding the court to exert undue influence of the court. Now, when African states are creating a new court, maybe they will go back to what they were saying back then and then try to create the court that they wish to had come out of the Rome Statute. But again, I don't also want to give this idealistic view of African leaders as being moral beings that would put in place a court that would be much better than the ICC, because of course that's not the case. A lot of these leaders do also have vested interest in having a system that would help them prosecute rebels in their territory rather than their own military forces.
Let's see, looks like David Blake Willis asks if there are alternatives to the ICC for accountability for states involved in ongoing mass persecution within their own territories, like the Uyghur, Rohingya, indigenous peoples. So what are other options beyond the ICC for ongoing atrocities?
Yes, thank you. That's a very good question. Because the way the ICC was created, it does not have universal jurisdiction. It can only get involved in specific instances. For instance, if a crime is being committed in a territory where the state is already a member of the court, or if the crime is committed by a citizen of a state that is a member of the court. That's why, for instance, the ICC cannot get involved in Syria right now, unless if there is a UN Secretary Council referral, and that has not been the case. In the case of the Rohingyas, yes, actually the ICC is getting involved now, not because Myanmar is a member, but Bangladesh is a member of the ICC. And the claim here is that because Myanmar had expelled the Rohingyas into Bangladesh, then the ethnic cleansing that they operated makes it as if they had already committed a crime in Bangladeshi territory. Therefore, the ICC does have jurisdiction there, and it's currently investigating. In all the instances regarding indigenous people, it depends on what crimes were committed and where. If these crimes have been committed, if they are genocide, war crimes, or crimes against humanity or aggression against the indigenous people in a country that is a member of the court, yes, the ICC could potentially get involved. At least it would have the jurisdiction to be involved. But the other issue is the temporal jurisdiction. The ICC can get involved only if the crimes were committed after 2002 or after that state's having acceded to the Rome Statute. So that's also beyond the territorial jurisdiction. There's also the temporal limitations in how the ICC can get involved in these cases.
We're starting to run a little short on time, so I'll gather a few questions. Sadaf and then Vladimir.
Hi. So I wanted to know, like, what incentivizes states to be involved with the ICC? and acknowledge its legitimacy when the attention of the abuses and its general attention is usually focused on these poor, less well-off nations, mainly in the global South. Because if you look at abuses that are going on, Putin's horrible, Saudi Arabia's horrible, there's a ton of countries that are, that have major issues, and yet the focus is almost entirely on global South in very vulnerable states, right? So to me, it's just what's the point? And I've been, yeah, I mean, you can learn from the structure of it. It's nice to look at and be okay, so this happened, that happened. But in reality, it's entirely ineffective, much like the UN and almost all global, systems, because it just focuses on poor brown people. Sorry, I'm just very annoyed with this whole, with this thing. Sorry.
Good. I mean, that's good. I like to see skepticism regarding global governance. That's good and refreshing to hear from my perspective at least. That's a good question. What incentivizes states to join the ICC? Right now, there is, I think, about 123 states that are members of the ICC, which means also, I think, maybe about 60 something. I don't know the number of states in the world, but there is close to 60 or 70 states that are not members of the court. So we could also ask the question, why did these states not join the court? One example, the glaring one, is the United States. The United States was there when the ICC was being created. They had a delegation. At the creation of the ICC, they had asked for a vote on the Rome Statute, although they voted against the Rome Statute because they were not happy with how it was drafted, the final draft of the Rome Statute. Yet President Clinton did sign the Rome Statute, although with no intention of sending it to Congress for ratification. When Bush came, thank you, there's 126 members, yes. So when Bush came to power, he unsigned the Rome Statute. I don't really know legally what does it mean to unsign, but the US has always held the view that the court is not legitimate to investigate or prosecute US citizens. The US actually went so far as to have Congress vote and the president sign into law what is oftentimes referred as the Hague Invasion Act. That's not the official name. But the Hague Invasion Act basically means that the Congress gives power to the United States president to use military power. So Congress gives authority to the US president to use the military power to go into The Hague and free any US citizens who would have been held in jail at the ICC. So that's law here. Again, this is to support your position that definitely there are some power dynamics going there. There are states that are outside of the reach of the court, whereas other states are subjected to the court's jurisdiction. But also these states have willingly joined the court. Uganda, DRC, Ivory Coast. Why did they join the court? Why have they been members of the court? My own country of origin, Senegal, is the first country in the world that ratified the Rome Statute. Why? States do have a lot of different reasons of doing it. But what I did argue the most in the book is that there is some benefits to be made in being part of this, as long as your own government officials are not the ones subjected to these investigations. So if you can have the courts go after the rebel leaders in your territory, then you are winning. Part of why the conflict in northern Uganda has ended and the LRA has been defeated is actually the ICC's involvement in northern Uganda, because by putting a warrant for the arrest of the top LRA leaders, that means they go into hiding. That means they are less able to wage their war. Sorry, I'll stop there so I can take more questions. I hope I answered your question.
Vladimir?
Thank you so much, Oumar, for an incredible presentation. My question is about the creation of the institution, right, and the temporal aspect of it all. So many institutions in international law and the international political system are created in the 1950s, right, immediately after, their post-World War II institutions. And so ICC really stands out in this respect. It sounds like it's the product of the 1990s, that it builds in some shape or form on tribunals for Rwanda and Yugoslavia. So what does it mean that it's such a young institution? What does it mean for how it operates, right? And how it's succeeding and failing today? Would you describe it as a post-Cold War institution, or is that dynamic not even relevant anymore? And then I was wondering, so your argument about the self-referral mechanism and how the national governments are going after their political opponents, what would you say was the switch, right? What was the precedent? When did states start doing this and figure out that that was, the way for the national governments to accomplish? Thank you.
Thank you. This is a good question. First one, the ICC as a young institution, you're right, the ICC is barely operational for 2 decades. But also, one could argue that if you are 20 years old, you are no longer that young. So yes, this is a post-Cold War institution, but another way of viewing it is an institution that came out at a euphoric moment of liberal cosmopolitanism. This is the 90s, this is the end of history, this is an incredibly, not joyful, but hopeful moment in world history where the international community could finally overcome its divisions and put in place this very ambitious project that's been in the works ever since the Nuremberg. So this has taken 50 years to build. A young institution, yes, in the early years of the ICC, until maybe about 5 years ago, a lot of the shortcomings of the ICC was being discussed as, this is a young institution, these are teething problems. That's the terminology that was being used, that the ICC is still trying to find its footing. But then again, after 20 years, 4 convictions, that's no longer just the fact that this is a young institution. So there are definitely bigger problems there, and the ICC itself has come to that realization. When these self-referrals they start, the first one was Uganda. So Museveni was the first president who invited the ICC to come and intervene against the LRA, but also because at the time the prosecutor of the ICC was Luis Moreno Ocampo, a very interesting figure who would go out of his way to actually coach these states into giving the cases to him. So that's why the first 3 cases of the ICC were all self-referrals. So within a 1-year period, you had both Uganda, the DRC, and the Central African Republic, all of them invite the ICC to come and prosecute rebel leaders in their territories.
So I'll just throw in one last question as we're almost out of time, but building on Vladimir's question, with the recent Afghanistan investigation and Israel-Palestine investigation, are we seeing, and the willingness of prosecutors to challenge some powerful states, are we seeing sort of bureaucratic politics playing out, and the ICC, or at least the prosecutor's office, trying to correct for past perceptions of bias or past issues and show, no, we can be useful. No, we can challenge strong states as well.
Yes, I think Prosecutor Bensouda, who has been the prosecutor for the last 9 years, her term ends this coming June. She's been kind of responsive to a lot of the criticism regarding the court. She's the one that expanded the court's reach outside of the African continent. She's the one that take up the Afghanistan one, also the Israel and Palestine one more recently. But also there's the fact that this Israel-Palestine thing has been ongoing at the ICC for more than a decade. So it has been a very slow moving and very cautious approach that the court has taken. But yes, it's definitely puts into doubt the idea that this court is not touching anything that goes against the interests of the powerful. So that's definitely a way of correcting the criticism that the court has encountered. But again, an investigation does not necessarily mean that there will be prosecution, that there will be warrant for the arrest to be issued against Israelis or Palestinians, or that even if that was to happen, there's nothing that tells us that it won't take another 10 years before we see that happening.
All right, well, we're out of time, but thank you so much, Oumar, for a great talk and for taking the time to answer everyone's questions so graciously, and really appreciate it and look forward to reading more of your work in the future.
Thank you all. This has been a very fascinating exchange, and thank you for having invited me too.
Thank you.